Mitchell, and he's working on this paper as part of his independent research class. He's going to be presenting as well in New Orleans during spring break. He's working with Dr. Lowe and Dr. Collum on that presentation, and then hopefully a publication after that.
All right, hello ladies and gentlemen. As she said, my name is Andrew Mitchell. Today I'm going to talk to you about the effect of name, image, and likeness, also known as NIL policies, and the role of college sports agents. And if you don't know, NIL has been plaguing ESPN for the last about year or two. If you watch ESPN for about 5 minutes, you will hear about it. Just a little bit about the pictures. As you see, this is a before and after. Before NIL, you would only see jerseys with no name on it, and it would be considered officially licensed material. But now, considering that college players can get paid, you will start seeing officially licensed material with their name. A little bit about NIL, like I said, it is an acronym for name, image, likeness, and as defined by the NCAA, it is an activity that involves the use of an individual's name, image, and likeness for commercial and promotional purposes. And the image that you see, those are just some different ways that they can get paid and not and still be considered eligible within amateur sports. A little bit of history of sports agents. The first documented sports agent, well, it wasn't Red Grange, but he was the first college player to have representation back in 1925. The biggest impact with sports and sports agents was Arnold Palmer back in the 1960s. And because of his big impact on sports, we now see the formation of professional players' unions and also the Uniform Athlete Agents Act. Just a little bit about those. The players' unions kind of come together to say what they pretty much define what a sports agent is. They define what they can and can't do, and the Athlete Agents Act, that pretty much tells them you can't do this, you can't do this. It kind of brings some ethics into the athletics. History of amateur sports on the collegiate level. It started with President Roosevelt and the Intercollegiate Athletic Association of the United States, also known as IAAUS, in 1905. A little bit about this. College sports has been going around even before 1905, but players were getting hurt and some of them were dying. So Roosevelt wanted to come up with some kind of system to help make it better and safer. They renamed the IAAUS to the NCAA, which is the National Collegiate Athletic Association, back in 1910. A little bit about the Sanity Code, which came in place after World War II. That was the first way that was the first code that came together that pretty much paid college players in the form of tuition. So, that just kind of, I'm going to talk a little bit more about player payment due to NIL. Title IX was what would be considered the first law to put equality when it came to scholarships, which would put, to some people would say, a restriction on player payment. So I'm going to talk a little bit more about the notable laws and lawsuits regarding NIL and player payment. It all starts with Section 1 of the Sherman Act of 1890. A little bit about that was that the Sherman Act pretty much tells, it's an antitrust act, and it talks about how you can't limit competition within the U.S. And all the laws that come after this regarding the NCAA revolves around suing because of violation of the Antitrust Act. The first one is the NCAA versus the Board of Regents in 1984. The NCAA was trying to limit broadcasting of certain college teams. They were only going to have four big games, and they only picked certain teams at the time. And other teams could not do any kind of televised events, and it costed them money. Due to that, the Board of Regents, they decided to sue, and they ended up winning. So now that's why we see a lot more college sports games on today than we did prior to 1984. The Professional and Amateur Sports Protection Act of 1992. So this was federally done, and it was to restrict sports gambling federally. Uh, it has been struck down recently, and so now states have the right to have their own sports gambling. The reason why this is important is because different sports gambling brought into the effective name, image, and likeness. They bet on not only just teams, but players as well. Going on to O'Bannon versus NCAA in 2014. So O'Bannon, as you can see, he is right up here, UCLA basketball player. He sued the NCAA for using his image and not getting paid for it. The NCAA was making money off of him due to his name, his image, and his likeness, but unfortunately it got struck down at the time, but it got revived again later, and they brought this into effect. Also, the Northwestern University and the National Labor Relations Board in 2014. Northwestern, they are a private school, and they were trying to come together to put a player union to help pay for their players to pay to play, basically. Unfortunately, it did get shut down for them, and one of the main things with this was that they were a private school. Even though they were part of the NCAA, they felt like there was a difference between that public versus private. Also, Murphy versus NCAA in 2018, that was the court case that struck down the Professional and Amateur Sports Act of 1992. So that allowed states to go back and make their own laws on sports betting. The NCAA versus Austin in 2021, this is the big court case that got us to NIL, and I talk a little bit more about that. The NCAA, of course, they're profiting off of the name, image, and likeness of players. Players were playing, all their stuff, all their jerseys, their images on video games were being sold, but they were not getting anything out of it. The NCAA, EA Sports, a lot of different entities and companies were profiting off of the players. One of the things was the limitation of education-related expenses. They felt that it started with them saying that, okay, we can't pay for this, we can't pay for that, because they are college students, and unfortunately they were being limited to what kind of payments that they could get, which was just tuition, but they couldn't pay for anything else to help go through education. They felt like it was a violation of the Sherman Antitrust Act, and this is what got them the win. It was a Supreme Court ruling, so it went through many different stages until it got to the Supreme Court, and in a landslide 9-0 vote, NCAA versus Austin ended up winning, so now this is why we have NIL, name, image, likeness today in sports. So as I said, the NIL begins in NCAA sports, so now players can get paid for their name, image, and likeness use. So kind of to wrap things with NIL and sports agents, now NCAA players are allowed to get professional representation. These are college students that we're still talking about. A lot of them probably have no idea what they need to do to get any money, and once they get some money, chances are they don't know how to deal with that either. So a lot of them are going to have player representation today. The NCAA, though, they do have limitations on pay to play. So unlike in the NFL and in professional sports, you have a contract of you play this many games, you get this much money. You are not allowed to do that in amateur sports within the NCAA. If you are caught doing that, you would be considered ineligible and you won't be able to play. The NIL laws they vary by state. So currently the NCAA has an interim policy, which I'll go a little bit more about in the next slide. But as of right now, it is a state-by-state basis. Different states have different laws, and I'll go a little bit more about that as well. NIL collectives. An NIL collective basically is just a group of people who form a company to give name, image, likeness opportunity to players. This is going to be an issue later on in sports because we don't have any kind of regulation with collectives at the moment. Also, there is no market cap on NIL deals and sports agents. So unlike in professional sports, there is a cap on the salary, but there is not a cap on the endorsements that are made in professional sports. And that is going to be the same with the NIL. There is no market cap, so that is why you're going to see a lot of sports agents flock to all these NIL deals. The NCAA and NIL, as I said, the NCAA has an interim policy. So, of course, they have to follow the law of the states first, but there are a few states that don't have an NIL policy in place. So what makes them eligible? Well, it's through their policy, and a lot of the states actually did make their laws based off of the interim policy that is put into place. Like I said, NCAA prohibits pay for play, and that's part of the NCAA interim policy, and that's pretty much what you're going to see in all the states that do have this in place. The NIL cannot be used as a recruitment tool. So in terms of the NCAA and the NIL, you cannot use a collective or use NIL as a way to say, play for my school, play for my school. You have to be equal and fair across all states. So the states in the NIL, currently there are 24 states that have enacted legislation. That means that there are 24 states currently, pretty much every state in the SEC, they have enacted NIL laws. There are 5 states that have enacted them, but they are not put into place just yet. And as you can see, there are a few, I have the examples, and a lot of them are going to have the laws put into place between now and 2025. In the meantime, they do have to follow the NCAA interim policies. And then there are also 10 states that have proposed NIL laws, but they have not been signed into legislation yet. So the future challenges regarding the NIL representation, potential lawsuits regarding and surrounding NCAA booster clubs and collectives. I have the SMU logo because if we all know about the Pony Excess, where the boosters were paying players with either money or cars to come and play for them. We're going to start seeing some lawsuits because we don't have any regulation with booster clubs and collectives just yet. Also, the potential increase in NCAA governance. The NCAA does have the interim policy, but in the future we are going to probably see the NCAA having to put a stop to certain activities that we might see that we just don't know are occurring just yet. Also, the sports agent definition in amateur sports is going to change as well. With the NFL and the NBA, they define what a sports agent is. You have to go through certification. You have to have so many years experience, and we don't have an NIL policy regarding any of that. So in the future, we probably will see what defines an NIL agent within amateur sports. So future research regarding NIL impacts on sports agents. NIL sponsorship versus professional sponsorship regarding revenue. That means, will we see professional sports having bigger salary caps? Will we see them have bigger paychecks because of the NIL? Also, sports agents and revenue variation by state laws. All the states are going to have their own laws, and we would like to see which laws are affecting NIL opportunities. There might be some states that are better than others in terms of how much they can make in one state versus another. Also, NIL deals and potential effects of professional athlete contracts. So when you start with the NIL, when you come out of college, or when you come out of high school and you're going to college and you get a $1 million NIL deal, and you don't play that well, but you still are eligible to go to the draft, and you do get drafted maybe as a 5th round pick, will that be coming to effect of, hey, I got paid $1 million when I got recruited to one of the universities. I want more money for my salary. We might see more of that, but because NIL is still such a new concept, we won't see that until the future. All right, any questions?
We have a question for our speaker.
So in marketing, we have a term that is very similar to NIL. It's called celebrity endorsement. Basically, celebrity can be anybody famous. Can be an actor, can be a singer, can be, comedy, stand-up comedy, or could be, professional athletes, right? So they may endorse a brand and get paid lots of money. So I would like to ask you, what do you think is the similarity and the difference between NIL and a celebrity endorsement?
Really, the only thing that is stopping that is the NCAA and the state laws. I mean, it's really similar. The only thing that was stopping them before was NCAA regulations saying that they can't be considered celebrities because they were just amateurs in sports. But we will probably see celebrity endorsements considering, but they will consider it name, image, likeness to keep in touch with the state laws and NCAA regulations.
You mentioned the sanity code.
Yes.
So in that name, is that sanity in the sense of like health or in the sense of like common sense, or what was that all about?
Well, it started, not too sure. It started right after World War II, back in 1948. There were I think it probably was a common sense thing because there were a lot of players that were playing in college and they would consider it a job, but they weren't getting paid for it. So they came up with the sanity code to help pay for tuition by being, I guess, an employee at the time.
Do you ever think state law and NCAA regulations are ever going to come into conflict? Have they already, or is that something that may happen in the future?
So that might be something that might happen in the future. Right now, the NCAA does have the interim policy, so once state laws come into effect, when all 50 states have their own laws, I don't see that there will be much NCAA overreach. However, one thing I did mention was that we don't know if there's going to be certain laws that in certain states that might have more competition just because their laws allow them to make more money. And that might be something that the NCAA considers in terms of putting a foot down to make sure that there's still equality amongst competition within the 50 states.
Thank you.
One thing to consider is obviously we use NCAA, but who knows 10 years from now if it's still going to have the same look, because as this comes out, there's already talk about the larger schools breaking off and kind of doing their own things. So it's almost the Wild West, but I think it's too early to tell because it's only the first year.
All right, let's thank our speaker again.